Coming to degrees of prohibited relationship. Now, degrees of prohibited relationship means a relationship which is prohibited. Why? Because a person who wants to marry A is a person who wants to marry B. So they both lineage is from the common person, like brother and sister. Uh, we can say it uncle and niece, aunt and nephew. So these kind of relationships will be treated as a degrees of prohibited relationship. Degrees of prohibited relationship. So these relationship, the relationship between these persons and the marriage between these persons are prohibited. Yes, Sham Shyamala Kotiada. We have asked a question. Yeah, the consanguinity. Consanguinity means ఏంటంటే consanguinity means by the related by blood only, right? So there it will comes under the Sapinda only. So blood means we have to fall back to these calculations like in which if the person is falling under these 5 generations from the father side and 3 generations from the mother side, that has to be calculated. So in that case, definitely it will be Sapinda relationship. Now coming to this, so in all these cases, Sapinda relationship lo మనం తీసుకున్నట్లు Sapinda relationship and degrees of prohibited relationship, the relation that how it will be connected అంటే ఏం చెప్తారంటే the relationship will be by full blood అయినా by full blood, uterine blood or half blood also is will be cover that will be if a person is related said to be related and by Sapinda relationship అంటే సో దట్ రిలేషన్షిప్ మేబీ హాఫ్ బ్లడ్ అయి ఉండొచ్చు, ఫుల్ బ్లడ్ అయి ఉండొచ్చు, యుటరైన్ బ్లడ్ అయి ఉండొచ్చు, ఆర్ బై అడాప్షన్ అయి ఉండొచ్చు, ఆర్ బై లెజిటిమేట్ అని ఉండొచ్చు, ఇల్లెజిటిమేట్ అయినా ఉండొచ్చు. సో ఇఫ్ ద రిలేషన్షిప్స్ ఇఫ్ ద రిలేషన్షిప్స్ అంటే ఏంటంటే రిలేషన్షిప్స్ ఫాలింగ్ అండర్ సపిండా రిలేషన్షిప్ అని చెప్తున్నప్పుడు హౌ దే ఆర్ రిలేటెడ్ అని ఎత్తుకున్నట్లయితే వాళ్ళు ఫుల్ బ్లడ్గా రిలేట్ అయి ఉన్నా సరే సపిండాలో కలిసి సపిండా జనరేషన్స్లో పడినట్లయితే 5 జనరేషన్స్ కానీ 3 జనరేషన్స్లో కానీ సో ఈ ఫుల్ బ్లడ్లో కనెక్ట్ అయినా హాఫ్ బ్లడ్లో కనెక్ట్ అయినా అడాప్షన్ ద్వారా అయినా సరే లేకుంటే లెజిటిమేట్గా అయినా సరే ఇల్లెజిటిమేట్గా అయినా సరే దీస్ రిలేషన్షిప్స్ ఆర్ కవర్డ్ అండర్ దిస్ సపిండా అండ్ ఆల్సో డిగ్రీస్ ఆఫ్ ప్రొహిబిటెడ్ రిలేషన్షిప్. సో సపిండాలో నో అండి ఇప్పుడు 5 జనరేషన్స్లో ఒక తాతకి ఒక జనరేషన్ వ్యక్తికి ఒక 2 పెళ్ళిళ్ళు అయినాయి, ఒకటి అన్లాఫుల్ మ్యారేజ్, సెకండ్ మ్యారేజ్ అన్లాఫుల్ కదా, సో ద చిల్డ్రన్ బార్న్ టు దెమ్ ఆర్ ఇల్లిజిటిమేట్ కదా, అసలు సంబంధం లేదు కదా, వీ క్యాన్ మ్యారీ టు దట్ గై అండ్ దట్ ఈస్ నాట్ పాసిబుల్. వై? బికాస్ దట్ ఈస్ ఆల్సో క్లియర్లీ మెన్షన్ దట్ ఈస్ ద రీజన్ వై ఇట్ ఈస్ క్లియర్లీ మెన్షన్ దట్ even legitimate, illegitimate children who are covering under the 5 generations from the father side and also 3 generations from the mother side, they are also comes under the Sapinda relationship. Even the persons who are adopted also will comes under this relationship. Coming to section 4, which is a overriding effect of this act. So this act is also, this section is also very important. So for every act there will be overriding effect of the act will be there, it will be provided a separate section. Why? Because it will shows to what extent this act is applicable. Extent means to which areas this act is applicable. In some cases we can see like a specific relief act like that. In that case also there is a section which will deals with this kind of similar thing. How means, so for all the terms, for general terms we have to refer to the contract law. The terms that are mentioned in this act, the specific relief act will be applied specifically like that. These things will be mentioned. So in this act, section 4, overriding effect of the act means whatever the acts which are present at the time of enactment of this Hindu Marriage Act, those acts will be overridden by this present Hindu Marriage Act. That is at the time of on 18th May 1955, whichever acts are pending, whichever acts are in force, or some other act, not only this act, some other acts, whichever acts are there, whichever acts are there. So those acts will be overridden by this act, giving the sanctity to all the marriages and everything. So to something this thing. Now coming to section 5 of the Hindu Marriage Act, which is very important section of this act. Conditions for a Hindu marriage. Conditions for a Hindu marriage. So a marriage may be solemnized between two Hindus, specifically mentioned two Hindus, if the following conditions are fulfilled. If the following conditions are fulfilled. First one is neither party has a spouse living at the time of marriage. Neither party has a spouse living at the time of marriage means we can discuss it in different ways. We will discuss now. So neither party having a spouse, neither party has a spouse living at the time of marriage means none of the parties, that means A and B are the bride and bridegroom, while they're getting marriage, A and B should be single, I mean unmarried till them. This is the first marriage to them, that is they are single. That is the first case, so they can marry. Second case, A is a single, B is a widow. So here B is not having husband, he was died. So in this case, A and B are single. So B's spouse is not living at the time of marriage. This, and in third case, coming to third case, A is a divorcee, B is a single person. Both are getting married. Both are getting married. Here also the prior marriage relationship is dissolved. So he is treated as a single. So that is how we should understand this specific provision. So neither party has a spouse living at the time of marriage. So both the persons should not be involved in any kind of marriage, and their marriage, if their marriages are done prior to the marriage, that should be dissolved prior to the marriage. But by the time of marriage, they should be single. Now coming to subclass 2. At the time of marriage, neither party is incapable of giving a valid consent. This section, we can literally say that consent. This provision, subsection of 5, subsection 2 deals with the consent for the marriage. So consent for the marriage shall be obtained. The person, because both the persons are, the marriage shall be performed with the free will and willful consent only. So we cannot obtain the consent of a person by practicing fraud or by deception or something else. So it should be free, and the person who is giving the consent should be capable of understanding the terms, should be capable of understanding the situations in what they are giving the consent. That should be noted. So here they have mentioned that neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind. So if a person is if a person is suffering with unsoundness of mind, there is no possibility for him to understand what is going there, circumstances are going there. So in that case, he cannot give the free consent. So the consent should be free. Though capable of giving a valid consent, has been suffering from mental disorder of such kind, or to such an extent as to be unfit for marriage and procreation of children. So here, the person who is capable of giving a valid consent, he is suffering from certain mental disorder, and he don't know the consequences of the marriage and the procreation of children. So that should be seen, and has been subject to recurrent attacks of the insanity. So where a person is recurrently attacked with the insanity, means insanity, so he is not a fit person to give the consent. That should be seen. Now coming to subclass 3 of section 5, which is a essential condition, that is the age limit for a persons who are entering into the marriage. For a bride groom, it is 21 years. For a bride, it is 18 years. Earlier, prior to 1976, the Hindu Marriage Act at the time of enactment of Hindu Marriage Act, this section, the age for a bride is 15 years, and it was amended to 18 years. So in the Amendment Act of 1976, it was modified and amended. Prior to that, what is the situation means, scenario means, Section 6 of this Act is in application. That means where a person where a bride is aged about 15 or 16 years, the consent is obtained from their parents. So that section 6 of this Act was repealed by enactment by the Amendment Act of 1970, Amendment in the year 1976. From then onward, the Section 6 has no application. In view of that Section 6 was repealed in view of enactment of Child Marriage Restraint Act. సో బాల వివాహ చట్టంని తీసుకొని వచ్చిన సందర్భం చేత ది సెక్షన్ 6ని ఏం చేశారంటే రిపీల్ చేయడం జరిగింది, రిమూవ్ చేయడం జరిగింది ఈ చట్టం నుంచి. సో నౌ ఇక్కడ ఏం జరుగుతుందంటే, సో ఫర్ ఏ bride it is 18 years age, and for bridegroom it is 21 years age. So now also there is a proposal that the marriage age for a bride should be increased from 18 to 21 years and should be treated, but that is not yet confirmed, and it is pending for approval. I mean, consent, the bill has to be passed and it has to take consent from the assent from the president.